Vice President.
Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen. Go ahead.
Announcements by the Vice President.
Honorable Senators, I have granted leave of absence to Senator the Honorable Dennis Moses and to Senator Sophia Choate SC, both of whom are out of the country. Honorable Senators, I have received the following correspondence from Her Excellency the President, Paula May Weeks, OR-TT. The Constitution of the Republic of Trinidad and Tobago, by Her Excellency Paula May Weeks, OR-TT, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces, to Mr. Ndali Young. Whereas Senator the Honorable Dennis Moses is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago, now therefore I, Paula May Weeks, President as aforesaid, acting in accordance with the advice of the Prime Minister in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Ndali Young, to be temporarily a member of the Senate with effect from the 11th of April 2019 and continuing during absence from Trinidad and Tobago of the said Senator, the Honorable Dennis Moses, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, this 11th day of April 2019. To Mr. Josh O.W. Drayton. Whereas Senator Sophia Choate SC is incapable of performing her duties as a senator by reason of her absence from Trinidad and Tobago, now therefore I, Paula May Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(c) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Josh O.W. Drayton, to be temporarily a member of the Senate with effect from the 11th of April 2019 and continuing during the absence from Trinidad and Tobago of the said Senator Sophia Choate SC, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, this 11th day of April 2019. Honorable Senators, Senators are required to take the oath.
I, Ndali Young, having been appointed a Member of Parliament, do solemnly affirm that I will bear true faith and allegiance to Trinidad and Tobago, and will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities of the people of Trinidad and Tobago upon which I am about to enter.
I, Josh Drayton, having been appointed a Member of Parliament, do solemnly affirm that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Bills brought from the House of Representatives, appearing on the supplemental order paper, the Civil Asset Recovery and Management and Unexplained Wealth Bill 2019, in the name of the Attorney General.
Attorney General.
Mr. Vice President, in accordance with Standing Order 62(1)B, I beg to move that the next stage of the Civil Asset Recovery and Management and Unexplained Wealth Bill 2019 be taken on Monday, April 15th, 2019.
Honourable Senators, the question is that the next stage of the Civil Asset Recovery and Management and Unexplained Wealth Bill 2019 be taken on Monday, April 15, 2019. All in favor say aye.
Aye.
Against say no.
No.
The ayes.
Division, sir.
Mr. Khan,
Yes.
Mrs. Gopi Schoon,
Yes.
Mrs. Batiste Primus,
Yes.
Mr. Rambaran,
Yes.
Mr. Sinanan,
Yes.
Mr. Hussain,
Yes.
Ms. West,
Yes.
Mr. Lehunt,
Yes.
Mr. Singh,
Yes.
Mr. Cummings,
Yes.
Mr. Dookie,
Yes.
Mr. Simonet,
Yes.
Mr. Augustus,
Yes.
Mr. Young,
Yes.
Mr. Mark,
No.
Ms. Haynes,
No.
Ms. Amin,
No.
Mr. Hussain,
No.
Mr. Obika,
No.
Mr. Ramdeen,
No.
Mr. Richards,
Yes.
Mr. Vera,
Yes.
Ms. Deonarine,
Yes.
Ms. Sipasad,
Yes.
Mr. Timal,
Yes.
Mrs. Thompson-Nahi,
Yes.
Dr. Dylan Remy,
Yes.
Mr. Drayton,
Yes.
22-6. 22-6. Mr. Vice President, the result of the division is 22 in favor, 6 against, and 0 abstentions.
Honourable members, the results of the division are as follows: 22 for, 6 against, and 0 abstention. The motion as moved is passed. The next stage of the bill will be taken on Monday, April 15th, 2019.
Papers.
Minister of Agriculture, Land and Fisheries.
Mr. Vice President, I have the honor to lay on the table the following papers listed on the order paper in my name. The ministerial response of the Ministry of Agriculture, Land and Fisheries to the 5th report of the Joint Select Committee on Land and Physical Infrastructure, 4th Session 2018-2019, 11th Parliament, on an inquiry into the state of agriculture and fisheries industry in Tobago, with specific focus on the levels of participation in the industries and the output of farmers. Thank you.
In the Ministry of Finance.
Mr. Vice President, I have the honor to lay on the table the following papers as listed on the order paper in the name of the Minister of Finance. The annual audited financial statements of MIC Institute of Technology, formerly Metal Industries Company Limited, for the financial year ended September 30, 2017, and the consolidated audited financial statements of Export TT Limited for the financial year ended September 30, 2017. Thank you, Mr. Vice President.
Leader of Government Business.
Thank you very much, Mr. Vice President. Mr. Vice President, I have the honor to lay on the table the following paper as listed on the order paper in the name of the Minister of Planning and Development. the ministerial response of the Ministry of Planning and Development to the 16th report of the Public Administrations and Appropriations Committee, 3rd session, 2017-2018, 11th Parliament, on the examination into the implementation of the Public Sector Investment Program.
Reports from committees.
Senator Richards.
Thank you, Mr. Vice President. Good afternoon, everyone. Mr. Vice President, I have the honor to present the following report as listed on the order paper in my name. The 8th report of the Joint Select Committee on Social Services and Public Administration, 4th session, 2018-2019, 11th Parliament, on its first follow-up inquiry into the current level of violence among students in schools, with particular focus on physical and cyberbullying. Thank you.
Senator the Honorable Clarence Rambarat.
Mr. Vice President, I have the honor to present the following report as listed on the order paper in the name of Senator Sophia Choate, SC. The 5th report of the Joint Select Committee on Finance and Legal Affairs, 4th session 2018-2019, 11th Parliament, on a critical assessment of the waste management policies and initiatives of the state, with special focus on solid waste. Thank you.
Questions and notice. Questions for oral answer.
Leader of Government Business.
Thank you very much, Mr. Vice President. Mr. Vice President, the government is pleased to announce that it will be answering all questions, even except question number 132, 196, and 197. Regards 196 and 197, we seek a 2-week deferral.
In relation to questions number 196 and 197, the deferral that the member seeks is so granted. Senator Mark.
Question number 99 to the Minister of Works and Transport.
Minister of Works and Transport.
Thank you, Mr. Vice President. Mr. Vice President, the Austral Ship Pty Limited is a global shipbuilder and prime defense contractor. This company is recognized as a world leader in the design and construction of customized commercial and defense vessels. Part 1. Austral, the Australian shipbuilder, was awarded a contract to design and build and deliver a 49-meter high-speed passenger cargo roll-on, roll-off catamaran ferry with a capacity of approximately 930 passengers, inclusive of 132 VIP seats, 150 cars, and with the accommodation for trucks and a prison holding cell for up to 10 persons. The price agreed between the parties is $73,550,000 US. Part 2, the tender process used in the award of the said contract was conducted in the following stages. The Cabinet agreed in May 2018 to an official visit by a delegation from Trinidad and Tobago to Australia, among other countries. The visit was part of the government initiative to seek solutions to improve reliability on the Inter-Island Sea Bridge. On that trip, the delegation was met with officials from Austral Ship Pty Limited and others. Arising out of the visit, proposals were received by the government of the Republic of Trinidad and Tobago for the supply of fast ferries and military vessels. In June 2018, Cabinet appointed a committee to review the proposals received. The committee was comprised of the Minister in the Office of the Prime Minister and Minister in the Office of the Attorney General, as he was then, the Minister of Foreign and CARICOM Affairs, the Minister of National Security, as he was then, the Minister of Public Utilities, and senior officials from the Ministry of Works and Transport, the Port Authority, the Maritime Technology Corporation Center of the UTT, the Office of the Prime Minister, and the Tobago Chamber of Commerce. After the previous committee reviewed the proposal, a new committee was formed comprising NITCO officials and other expert advisors to conduct an in-depth discussion with Austral to finalize specifications and determine contract parameters. These decisions took place during the period August 27 to 29, 2018 at the Office of the Ministry of Works and Transport. Haynes and Boone, CDG of the United Kingdom, was engaged to provide legal support during the negotiations. This international law firm has global capabilities in the energy, maritime, financial service, corporate, and project finance sector, and has built a significant international reputation serving the shipbuilding sector. Its shipbuilding clients consist of ship owners, charterers, and shipyards, covering the entire spectrum of commercial shipping, including the international superyacht sector. Over the 3-day period, this committee discussed several issues inclusive of clarifying the technical, operational, and maintenance requirements, risk assessment, including financial risks, commercial issues surrounding the price proposal, proposed delivery dates, and other contractual issues. Since the conclusion of these negotiations, through various correspondence, the parties have finalized the vessel specification, the contract sum, and a recommendation was made to the award of a contract to Ostal for the construction of a 94-meter high-speed passenger cargo roll-on, roll-off catamaran ferry at an estimated cost of $73,550,000. I thank you.
Mr. Mark.
Mr. Vice President, can the Honorable Minister indicate when was this contract concluded? They awarded a contract. When was it concluded?
Minister of Works and
Thank you.
Transport.
Mr. Vice President, I will not have at this point in time the exact date the contract was signed. However, I did indicate the period of the negotiation, and subsequent to that, the contract was signed and the down payment was made. But I can furnish the Honorable Senator with an exact date of the signing of the contract, if so required.
Well, I do require it, sir.
Senator Mark.
Yeah. Mr. Vice President, can the Honorable Minister indicate whether the Central Tenders Board had any role whatsoever to play in this awarding of this contract to Ostal? Was the Central Tenders Board involved?
Thank you, Mr. Vice President. I did indicate the process that was used, and this is an arrangement that has been facilitated by the Government of Australia through their exempt bank. And having done that, there was no role for the Central Tenders Board because the Australian exempt bank will not finance a vessel that is not built in Australia. I thank you.
May I ask the Honorable Minister whether this fast ferry is being built in Australia?
Thank you. Mr. Vice President, this government contracted Ostal of Australia. The Honorable Senator will know that you may buy a car, just to break it down in the layman language, from a certain company. The car might be an American car. Sometimes these cars are made in Japan. All right? We would have contracted Ostal Shipbuilders of Australia. And that is who we are dealing with. So wherever the vessel, the parts come from, or what part of the vessel, we are contracted with Ostal of Australia. Thank you.
Senator Hussain.
Thank you very much, Mr. Vice President. Mr. Vice President, having regard to the Minister's answer with respect to the preferred choice of Ostal and the specifications of the vessel, can the Minister indicate whether or not it was a consideration for the government to select Ostal based on the fact that the Ostal vessels use an aluminum hull, and there have been several challenges with respect to these vessels in the US, in Puerto Rico, and several European countries? Can the Minister indicate, having regard to all of these factors, why Ostal was still selected when their vessels have had a lot of defects in the past, Mr. Vice President?
That question, Senator Hussain. Next question, Senator Mark.
It's not.
Mr. Vice President, we were told that Haynes and Boones was engaged by the government to...
Senator Mark, are you asking the next question on the order paper?
No, we have 4 supplemental acts too. Senator Hussain asked 1, so I have a 4th.
Go ahead.
So I'm asking the Honorable Minister, Mr. Vice President, can he provide to the Senate the cost of the expertise in terms of fees paid to Haynes and Boones in offering advice for the consummation of this award of the contract?
Minister of Works and Transport.
Mr. Vice President, I will most certainly make the fees available to the Honorable Senator, but I can indicate it is a lot less than what this country paid for legal fees between 2010 and 2015. I thank you.
Next question on the order paper, Senator Mark.
Yeah?
Insurance.
100 million plus one.
Question number 100.
Okay, Senator Mark, 1 second. Could we allow the process of oral questions to continue without the elevation of noise in the chamber? I would like to hear the question, hear Senator Mark ask the question and then the subsequent answer. Senator Mark, continue.
Yes. Question number 100 to the Honorable Minister of Works and Transport.
Minister of Works and Transport.
Thank you again, Mr. Vice President. Mr. Vice President, again, this question, let me don't get too political with it. There's no agent, and there has never been an agent acting for Ostal, for the new ferries and military vessels, or anything else. In discussions, negotiations, or transaction with the government or with any government department, statutory authority, state enterprise, or government agencies in Trinidad and Tobago. As such, since there were no agencies acting for Ostal, this part of the question is not applicable. And since there was no agent acting for Ostal, no commission could possibly be paid. I thank you.
Senator Mark.
Yeah, Mr. Vice President, in terms of the award of the contract for the construction of this vessel, can the Honorable Minister indicate when this particular vessel will be delivered to the people of Trinidad and Tobago?
I won't allow that question, Senator Mark. Next question.
Well, since there are no agents involved in this particular transaction, I would like to ask the Minister whether the government is comfortable with Ostal building this vessel in Vong Du shipyard in a warehouse in Vietnam. Are you aware of this, Mr. Honorable Minister?
I won't allow that question, Senator Mark.
Well, Mr. Vice President, I think my colleague has one.
Senator Hussain.
Thank you very much, Mr. Vice President. In light of the Minister's answer with respect to the agent, and this vessel was selected on a visit by the Prime Minister and the Minister of Communications to Australia, can the Minister then confirm whether or not the Prime Minister and or the Minister of Communication acted as the agent for Ostal in this deal, Mr. Vice President?
Minister of Works and Transport.
Mr. Vice President, I never indicated that the Prime Minister or the Minister of Communication chose this vessel in Australia. The Prime Minister and the Minister of Communication and a delegation visited the shipyard. This vessel was custom built, starting from scratch, for the purpose of Trinidad and Tobago. The Prime Minister of Trinidad and Tobago is the Prime Minister of Trinidad and Tobago. He's not an agent of the Port Authority. Thank you.
Senator Mark.
But what prompted the Prime Minister to purchase or to order this particular vessel? Did he just get a VAPS that he must purchase this vessel?
Minister of Works and Transport.
President, so now I think about the questions that they asked. The reason why the Prime Minister had to make a visit to ensure that we have a vibrant sea bridge is because between 2010 and 2015, the previous government run down the vessels at the port. And this country was placed in a predicament.
Right, Senator Hussain, there's no need to shout across the floor while the minister is responding to a supplemental question. Let me just remind members of my last ruling Tuesday night. Don't forget it. Still applies. Continue, Minister.
Mr. Vice President, I was saying, it was in 2013 that the previous board of the Port Authority took a decision to cancel the contract of Bay Ferries. That was the company that was maintaining the two fast ferries. They reduced the contract from 3 years to 2 years to 1 year and put nothing in place for when Bay Ferries leave our shore to maintain the vessels. That, as a result, was the end of our two fast ferries to some extent. We spent millions of dollars trying to get one back up, and one is virtually impossible to bring back on the sea bridge. And that is the reason why the Prime Minister had to go out there and use his influence to ensure that the Australian government supported us in getting vessels to serve the sea bridge between Trinidad and Tobago. I thank you.
Senator Mark.
I wonder if it's the reason why Fudi Ferreira
Senator Mark, ask a question.
confirmed that it's your government that ended the Bay Ferries contract. Anyway, Mr. Vice President, I couldn't allow this misinformation to stay on the Hansard when he knows otherwise.
Senator Mark, ask a question.
Mr. Vice President, I ask a question. Question number 102 to the distinguished and future Prime Minister, the Minister of Public Utilities.
Minister of Public Utilities.
That's what they call a setup. That is what they call a setup.
This question, as appears to be customary, is a classic fake news. The government has not been engaged in any discussions with anyone regarding the privatization of the Cove Power Station and has no intention, I repeat, no intention of privatizing it.
Senator Mark.
Can the Honourable Minister indicate whether it is the intention of the government to have the Cove Power Station refurbished? Can you answer that?
I won't allow that question, Senator Mark.
Well, can I ask him whether the government has any intention whatsoever to have any discussions in the not too distant future as it relates to the possible divestment of this particular organization? Is there any intention in the future, in the not too distant future?
Minister,
not in the immediate period, but in the future.
Minister of Public Utilities.
Mr. Vice President, again, I am saying that the government, and what's called in keeping what I've said before, has not been engaged in any discussions with anyone regarding the privatization of the Cove Power Station and has no intention of privatizing it. Asked and answered.
Senator Hussain.
Question number 172 to the Minister of National Security.
Minister of Agriculture, Land and Fisheries.
Mr. Vice President, I respond to this question on behalf of the government. Mr. Vice President, according to the information provided by the Commissioner of Police, for the period September 30th, 2015 to January 31st, 2019, 7,076 applications for firearm users' licenses were received, and of that number, 1,808 firearms users' licenses were issued. Thank you very much.
Senator Hussain.
Mr. Vice President, having regard to the large number of applications that were made for firearm user license and the small numbers that were granted, and complaints from members of the public, especially the business community, can the Minister indicate whether or not any steps will be taken to expedite the outstanding applications?
Minister of Agriculture, Land and Fisheries.
Mr. Vice President, I must apologize, but I'm not in a position to answer that question. That is, the grant of FULs is a matter for the Commissioner of Police, and if I have to answer that, I'd have to seek the information from the Commissioner of Police. Thank you.
Senator Hussain.
Mr. Vice President, can the government then indicate whether or not any additional resources will be given to the Commissioner of Police for the expedition of these or granting of these firearm user license?
I won't allow that question, Senator Hussain. Any more supplementals?
Public.
No, Mr. Vice President, I have a number of questions on the appendix that are due today. Can you advise me as to whether they will be circulated?
Leader of Government Business.
Thank you. Thank you very much, Mr. Vice President. We will be circulating answers to question number 164, 189, 190, 191, 192, and 193. We ask for a 2-week deferral of 194, and 213 is not due as yet.
The deferral that the member seeks for question number 194 is so granted. Senator Mark, as you've heard, 164, 189, 190, 192, and 193 will be circulated. Senator Bika, you have a question?
Yes, Mr. Vice President. Just confirming, I may have missed it. Questions 196 and 197, are they deferred?
Leader of Government Business, 196.
Yeah,
Yes, Senator Bika, 196 and 197 on the order paper today was deferred earlier.
Thank you.
Public business, government business.
Attorney General.
Mr. Vice President, I apologize for arriving slightly late to my point. Mr. Vice President, in accordance with Standing Order 66-1, I beg to move that the bill be committed. I'm just looking for the correct language on this procedure.
Top of page 5.
Yes, Mr. Vice President, apologies. Mr. Vice President, in accordance with Standing Order 66-1, I beg to move that a bill entitled An Act to Provide for the Registration of Non-Profit Organizations, the Establishment and Maintenance of a Register of Non-Profit Organizations, the Obligations of Non-Profit Organizations, and for related matters, be committed to a committee of the whole Senate forthwith to be considered clause by clause. Thank you, Senator.
Honorable Senators, the question is that a bill entitled An Act to Provide for the Registration of Non-Profit Organizations, the establishment and maintenance of a register of non-profit organizations, the obligations of non-profit organizations, and for related matters be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause. Are you ready?
Yes, sir.
Okay. Honorable members, on the last occasion of Senate sitting on Tuesday, the Honorable Attorney General did indicate that he would be moving amendments and that they would be circulated. Just a matter of housekeeping. Is everyone in receipt of said amendments moved by the Attorney General? Yes? Okay. As well, today, in this sitting, we've also had amendments circulated by Senator Drayton. Is everyone in receipt of those amendments? A copy, yes? Okie dokie. So we can begin. The bill before us has 29 clauses and 1 schedule. Members, as per usual, are allowed to move amendments as we go through clause by clause. Clerk? Senator Hussain?
The Attorney General, one dated the 9th of April and one dated the 11th. Which one are we relying on?
Attorney General?
Mr. Chairman, we're relying on the latter one, the one from today. There were some cross-reference changes that we wanted to make just numerically. And very importantly, we, in a further scrub, realized that we should be exempting the Registrar of Friendly Societies. So that's the only difference in there, some numerical changes. In meeting with the non-profit organization sector, as I did over the several days, including up to yesterday, they asked us to change, for instance, a couple of days, 14 days to 30 days. We agreed with those. So we've done numerical changes, some time frame enlargement, and we've added in the Registrar of Friendly Societies.
Okay, thank you. The 11th.
Okay, so given those statements, let me ask the question again. So the amendments circulated by the Attorney General today, does everyone have that in their possession in front of them? Great, perfect. Clerk?
Clause 1.
Honourable members, the question is that Clause 1 stand part of the bill. The question is that Clause 1 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 1 now stands part of the bill.
Clause 2, sorry.
The question is that Clause 2 stand part of the bill. The question is that Clause 2 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 2 now stands part of the bill.
Clause 3.
The question is that Clause 3 stand part of the bill.
Mr. Vice President.
Senator Ma.
Mr. Chairman, rather. I noted that there's mention in this legislation on the matter of gifts, and nowhere in the definition section or the interpretation section is there a provision that refers to gifts. You know, in the Integrity in Public Life Act, there is a provision that deals with gifts. And if you get a gift value beyond a certain some financial amount, you have to declare it. And if it falls under that amount, you're not obligated to declare it. But in this legislation, reference is made to gifts, but nowhere in the interpretation section. So I don't know how the members of the NPO community would be guided on this matter of gifts, because as you would see, they have to account for every gift that is being given.
Mr. Chairman, may I please recommend that we take a very orderly approach to this committee stage? The opposition has circulated no amendments. Senator Drayton has an amendment to Clause 3. The government has none. And the opposition has already categorically stated they're not supporting this law. And insofar as in the time frame between Tuesday to today, we've not received a single written proposal from the opposition. Their stated position is on record. Senator Drayton has an amendment circulated. Could I invite us to consider those which are circulated first, and then perhaps go into discussions? Of course, I'm in your hands as to how this is to be dealt with.
Mr. Chairman, for the record, the opposition's position is that it will not support without consultation from the NPOs. we did indicate that, not that we categorically would not support, for the record.
Okay. All right. As far as the procedure is, we are going through the clauses, clause by clause, and individuals, Attorney General, are allowed to indicate or have some sort of discussion as to any amendments they wish to proffer. We will address all the amendments, those that have been circulated and those that will be put on the floor. And I think that as long as we are going clause by clause, we will be taking that in an orderly fashion. I do recognize that Senator Drayton has put forward in a written fashion amendments to clause 3. When I, from a procedural standpoint, ask the question and take the slight pause, then members will indicate as to whether they have any amendments and so forth. We will address all of them, and there's a procedure to follow as we dispense of or treat with each amendment as proposed on the floor.
As I understand the procedure, Mr. Vice President, under the standing orders, we must deal with written amendments. I understand we have a practice of some general discussion, certainly in considering written amendments, but I don't understand that we just start off with questions in the dark. I mean, I understand it and have always understood it from my years in the Senate, in particular, that we go with written amendments first. That puts an order and context to this discussion.
Why are you challenging the ruling of the chair? Chair's rule.
All right. Okay, let me just state, after taking it under advisement with the clerks who are here to obviously assist the chair and the presiding officers, that what the Attorney General is saying is true, and therefore we will be taking the written and circulated amendments and dispense with those first, and then dealing with the general amendments if they come after. So that being said, Senator Drayton, you have amendments to clause 3. Proceed.
Thank you, Chair. So just to clarify that the amendments that I have, excuse me, that I've proposed here, these are amendments that came from the Civil Society for Good Governance and other 90-plus civil society organizations that consulted with me and suggested that I include these. So just to kind of lay to rest some of the issues of consultation in the room. So in terms of subparagraph 1, definition controller, there's a question around D, senior officer of the nonprofit organization, and that being confused with directors, because you have officers of the board, and then you also have the persons who are responsible for the management of the organization, that's C. So I'm suggesting that D be deleted since they're covered in both A and C, unless the Attorney General, Honorable Attorney General, could offer some clarifications. Sure.
Thank you. May I, Mr. Chair? I welcome the suggestion, and I'd also like to indicate that the government did, in fact, up to yesterday, meet with representatives of the 89 other entities, and we had very fulsome, and we, in fact, circulated the written amendments to them, and I received feedback that the amendments were very welcomed and addressed the issues raised by those societies. So I welcome Senator Drayton's resonating position to that, because we're taking 89 plus 94. So I welcome the Honourable Senator. If I could explain, we take a graduated approach to this for the purpose of catching incorporated and unincorporated entities, because they're of different types and structures. Specifically, we do catch the formal positions, director of a non-profit company, because that's specifically registered under Part 5 of the Companies Act. So that one we know with certainty that there's an actual position or locus in law for that category of person. We then went to, in B, a trustee of a trust, because again, that is known. C, a person responsible for the management or administration of an unincorporated body where the non-profit organization is established as an unincorporated body. Again, that one is with certainty and with reference to the people that actually have responsibility. The reason why we went with D is because we may very well not be with the incorporated or unincorporated established body, because we are now looking for another order of priority, and that's where we went to senior officer. So it was intended to make sure that you could take a priority approach. Do you fit a definition because it exists in law? You're a director of a company, you're a trustee. Do we go to management where there's an established unincorporated entity and therefore that's known? And then the other sweeper provision is what D intended to do, a senior officer. So it really was intended to cast a priority applied approach to this. So CPC's department, we did look at it and we welcomed this suggestion, but we felt that if we were to remove it, we may perhaps unwittingly in some circumstances lose that. But I do welcome the discussion on the benches.
Thank you, Chair. I understand the amendment, but if you look at the Companies Act, there's a distinction between a director and an officer. They're not necessarily one and the same. So if you look at the definitions in Companies Act, you'll see a director in relation to a body corporate means a person occupying therein the position of a director by whatever title he is called. And then officer is similarly defined in relation to a body corporate means could be chairman, deputy chairman, and most importantly, the company secretary. And if you go down lower in the Act at 99, you'd see duty of directors and officers. So I think it's important to maintain the distinction.
Any other comments in relation to that line of clause 3? Okay. Senator Drayton, there's a second part to that clause in terms of the amendment dealing with E, deleting own.
Sure. Given that MPOs are not owned, I wanted to understand. Okay, thank you.
We thank the Honourable Senator. We agree.
You agree?
Yes, sir.
Okay.
And should I continue?
We also agree with monetary worth of property and assets acquired. And if I may, I apologize, Senator Drayton, I'm stealing some of your run-up. Official receiver is in fact defined. We amended it in the Companies Act under the Companies Amendment Bill, which we did in the Senate. And the official receiver is defined as the Chief State Solicitor. So we thank you for that. And we did have a definition in Section 366 of the Companies Act as well. But we clarified that in the Companies Amendment Act. So, Mr. Chair, for the record, having distinguished the rationale between us on definition of controller in deletion of D, hopefully the Honourable Senator is satisfied with that and may or may not remove his position, withdraw that one. And having answered the last one, which is that official receiver is defined, we agree with the other two proposals. So I don't know, insofar as you may wish to put this amendment to the vote, if the first and the last were withdrawn, we would be agreeing with Senator Drayton's amendments. But that would be for Senator Drayton to put on the record.
Okay, so Senator Drayton, as proposed in written form, your amendments to clause 3, are you in agreement to dispense with what you've amended as circulated? So are you in agreement, to dispense with the first part of the amendment as you've circulated and only circulate the last 3, which is in agreement with the Attorney General? No?
No, sir. I'm asking Senator Drayton. You see, if the question is put to agree to your amendment as circulated, we'd have to say no, because we don't agree to all for the reasons expounded. So what we're inviting, if you're minded to do it, is that you would withdraw the first bracket and the last bracket, because official receiver is in fact defined, and we prefer to keep the definition in C, which you've proposed to delete, for the reasons that both Senator Vera and I share. So if you're minded to do that when your question is put, then we can say yes to your amendment. Otherwise, we'd have to say no and then propose 2 of the 4 things you did.
Chair, I wish to withdraw the first and the fourth amendments
to clause 3.
Much obliged.
You're welcome.
Okay, so okay. Honorable members, the question is that clause 3 be amended as follows. In subparagraph 1, definition controller, E, delete owned, and in subparagraph 1, definition gross annual income, F, delete monies worth and replace with monetary worth of property and assets acquired. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it.
The question is that clause 3 as amended now stand part of the bill.
Right. So, Honorable Senators, the question is that clause 3 as amended now stand part of the bill.
Well, did I not?
No, we're dealing with.
Oh, okay.
Right. So again, Honorable Senators, the question.
No, if there are other amendments to 3, we need to take them first. Yeah. No, if there are any others, we need to take them before we put the question. So if he has others to 3.
Okay, all right. So I'm being advised that if we have any other further comments or amendments to clause 3, that we will take them now before I finally put that question. Amendments. Senator Mark.
Mr. Chairman, I want to take charge of this committee and let nobody else take charge. Okay. Yeah. I am suggesting for clarification that there is the word gift used in many sections of this legislation, and there is no definition as to what it means, and this could be confusing to these ordinary people's organizations called NPOs. So I'm asking, Mr. Chairman, whether the government is inclined to look at this lacune in the legislation and to consider whether there is need for a definition of the word gift under the interpretation section. It's just for the consideration of the government.
Mr. Chair, what I want to be very clear about, because I'm very concerned about time management today. Senator Amin put forward the opposition's official position that they are not supporting the law unless there is more consultation. We have not stopped to have the kind of consultation that Senator Amin has referred to, because the opposition said take it to a joint select committee, pause the bill, etc. So I want to be unusually sharp in how I approach this issue from a time management point of view, because I really don't want to be entertaining a very long discussion in respect of amendments which are not written in a circumstance where the opposition is just going to say no. So that's what I'm concerned about, Mr. Vice President.
Mr.
Who's in charge here?
Mr. Chairman.
Has made a statement. Allow me to respond to that. I don't need any extra commentary.
I'm cool with that. I'm not listening to him. Mr. Chairman.
All right, Attorney.
That's why you didn't.
Right, so,
Mr. Chairman.
Attorney General, understanding what you've said, and as much as time management falls to the chair, in terms of treating with the bill that is before us, what I am always inclined to do is to ensure the rights of each member is protected. As much as amendments are to be circulated prior to the start of the proceedings for the view of all members and to be discussed as we go through clause by clause, members are also allowed to engage in very small discussions in relation to a clause or something that may have come up at that particular point in time. Any statements that would have gone in relation to the debate as to whether they support or not does not prevent that right to have a discussion on a particular clause if it comes up. Attorney General, it is up to you at that point in time, being the person who is piloting the bill or moving the motion, to either engage or not engage or state as to whether you are inclined to accept or not accept those amendments. That is the procedure that we'll follow. I will manage the time in relation to this bill so that there's no drawn-out, long discussion or engagement of any debate in relation to any of the clauses. That part of the procedure is over. So that is how we are going to proceed. It's how we have proceeded for various bills that have come before the Senate. Attorney General, so we will keep it tight. Rest assured, I give you that assurance. But I'm not going to encroach upon the right of members to speak on a particular clause.
Well,
I will, as you have
appreciate,
indicated,
yeah.
and as the standing orders have put forth, take the written questions as priority, the written amendments, sorry, as priority in that regard.
If I could, and I accept and welcome your direction, and by no way seek to challenge it. And I just want to explain, just for the record, lest it be twisted, my rationale is grounded in Standing Order 68.1. The clerk of the Committee of the Whole shall call the number of each clause in succession. A, the chairman shall propose the question that the clause stand part of the bill. B, a discussion shall ensue during which amendments may be moved. Amendments must be in writing and handed to the clerk. So I accept that we have a full discussion, but you see, the only reason that I'm taking this approach today is in light of Senator Mark's party's and the opposition's position in relation to this bill. So I want to mark the spot carefully, because maybe it's the fact that I've been in Parliament 4 days straight, but the point is that I have noticed a particular trend in the opposition, and today is not the day that I want to indulge certain activities. So I'm guided by you. I just wanted for the record to state why I said what I said and why I asked for the direction. I'm perfectly happy, sir, to be guided exactly as you've already said, so I will not detain us any further.
All right, Attorney General, noted. We will not, like I said, prolong today's proceedings by going into a back and forth.
And I choose, therefore, if I may answer the question put by Senator Mark, I don't agree with the need for any definition. It's the plain and ordinary meaning, and that is perfectly capable of standing on its own.
And that is quite fine. So as to keep the proceedings moving, anybody else? Comments on Clause 3? Senator Mark?
Yeah, Mr. Chair. We wanted to get some clarification on this matter of cash. If you look at Clause 3, we don't know whether this definition is necessary. When we look under the Companies Act, we haven't seen this definition of cash emerging or in any other tax legislation. We know about the definition of money under the Value Added Tax Act, which, Mr. Vice President, we have the view should be adopted for consistency. But the definition does not address the issue even of virtual currencies. So this question of the definition of cash in this particular in this part of the legislation, having regard to what we have seen under the Companies Act, and when we looked at, for instance, other tax-related legislation, there's no such definition. So we do not believe this is really necessary or relevant for the legislation at this time.
Attorney General.
Mr. Chairman, there are no amendments put forward by the opposition, and therefore I am not entertaining any of the opposition's points of
That is
view.
for the chair to decide.
Specifically on this particular matter, and I'll tell you why. The position in relation to cash, I haven't even heard the honourable member say what he wants instead. So we're having a debate and a discussion on something that is not crystallized. On a clause-by-clause basis, we're now going into the sub-issues word by word, and the reason that I've been very strict today in my recommendation, Mr. Vice President, is that we're going to enter into a frolic, Mr. Vice President, Mr. Chairman. And in relation to the definition of cash, had the honourable member gone to look at the Anti-Terrorism Act, etc., he would find these things covered. So not only do I disagree with the submissions made, but it is coming in a disorganized fashion.
Senator Ramdean.
Mr. Chair, the suggestion that Senator Mark has made is a comment that finds its root in the communication that was presented to the Law Association, by the Law Association.
Okay, so before I allow Senator Vera to weigh in on this, the procedure that we're following, so the Attorney General has indicated that he's not inclined, and just correct me if I'm wrong, Attorney General, to accept any amendments coming on the floor.
No, sir, that isn't generally it. I have had a few years' well experience in this Parliament, if I could be permitted to put this. And my actions have always demonstrated that we're prepared to take genuine contributions, including those coming from the opposition. That's a fact. You can judge me on my actions. But where we are going to enter into an exercise which is going to be of the type that I well anticipate today, Mr. Vice President, because there have been very clear positions drawn in relation to this in the debate. I'm very concerned that we do so in a proper way. So I can go through the question by question and answer and distinguish it. I don't want to stymie discussion, but I'm just marking the spot carefully as to my deep-rooted suspicion in the opposition's objective today. So in relation to the definition of cash, we have looked at the definition of cash in other jurisdictions. We went in our definition of cash to a type which includes things, for instance, which are contemplated in other jurisdictions, bearer negotiable instruments. We, of course, prohibited those in our own jurisdiction when we went to bearer share certificates. But bearer negotiable instruments or certificates may exist in other jurisdictions, and there is a certain degree of extraterritoriality, and therefore we count them. So we're quite comfortable with the recommendation for cash as set out in the bill.
Senator Vera, you had comments?
Thank you. Just to help on the debate, Senator Mark's point does have some validity. Cash is not a word that one ordinarily comes across. I did look at the anti-terrorism bill, and what is defined as money. Now, so if you were to substitute money for cash, it almost equates the two definitions come. Now, in the Interpretation Act, there's no definition of cash, and there's no definition of money, but there is the old designation coin. I don't think anybody uses coin today, but perhaps money might be a possibility.
I welcome the observation. We specifically wanted a definition of cash. We didn't want it to be reliant upon the ordinary and plain meaning under the Oxford Dictionary sort of approach, the literal interpretation aspect. And what we did in looking at the other jurisdictions is to lift from a definition of cash. We did not go to monies, anti-terrorism type, but we did want to drill into cash itself. I know the Cayman Islands and the British Virgin Islands have some model references to cash. In specifically if I look to the anti-terrorism definition for cash, this is beyond monies, right? I lift exactly from that, from the amendments that we made during the course of the several years gone, including 2017. 13 of 2018, it was last year, forgive me. Cash includes coins and notes in any currency, postal orders, checks of any kind, including traveler's checks, banker's drafts, bearer bonds, bearer shares, and bearer negotiable instruments, and any other bearer negotiable instrument in any currency. So in keeping a consistent approach, we went there. The old definition of money had that word cash. Cash was not previously done. The recommendations coming from the FATF said, let's get a definition from cash. There's a model description as to what that is. We applied it in the Anti-Terrorism Act, and we're seeking to be consistent here.
And for the record, I don't have a problem with the word cash. I think it's a word that people use ordinarily, and by having it defined, I think that would clarify.
Senator Hussain.
Mr. Chair, I just want to re-emphasize the point earlier that Senator Mark had raised with respect to the definition of gift. Now, I looked at Section 27 of the Integrity in Public Life Act, and a gift was defined as a personal benefit that exceeds $5,000. Now, it gives a threshold in terms of what would constitute a gift. As it stands now, we don't know what will constitute a gift under the present legislation. And if the aim of the legislation is that of countering financing of terrorism, money laundering, there must be some definition with respect to gift, because then you defeat the entire purpose of the legislation.
Mr. Chair, that is not the purpose in similar terms to the Integrity in Public Life Act. The reason for the threshold in the Integrity in Public Life Act was so that persons in public life didn't have to declare things which were innocuous, and they therefore had a certain threshold limit. We are applying in this law, firstly, a requirement that you register in one unitary place, and very importantly, we're proposing that you be regulated in a particular fashion, which Clause 4 of the bill is going to say how it is to be done. We have amendments proposed in Clause 4, which will treat with a risk-based approach to be applied by the Financial Intelligence Unit, and therefore we do not agree that it is critical that we have an exception limit for gift, because these are legislative purposes with different intents and different mischiefs entirely. So we are not in pari materia with the Integrity in Public Life Act.
Yeah.
We're not looking at that. We believe that the interpretation of gift can stand on the plain and ordinary meaning of the word, and we prefer to not accept the recommendations coming now for the second time from the opposition
Chair,
on the same point.
just to correct, I think the Attorney General is misinterpreting. The suggestion is not that we take the very same definition from the Integrity in Public Life. I think Senator Hussain is indicating that in the Integrity in Public Life Act, gift is defined. So in this act, gift should be defined, as opposed, and I understand what the Attorney General is suggesting, that we rely on the ordinary dictionary meaning of the word gift. But to be on the safe side, I think it should be defined. It doesn't have to be the same wholesale from the Integrity in Public Life Act.
And, well, Mr. Chair, you see the point is gift as is defined in the Integrity in Public Life Act is done so by way of reference to a threshold because of the Integrity in Public Life Act aim. So we're not intending to apply a threshold for gift. There will be a risk-based approach with different sizes fitting different categories as the FIU will develop in its guidelines and publications pursuant to Section 18 onward of the FIU legislation.
Okay, so I think we've had enough discussion on that particular line. AG has indicated he's not willing to accept that, and therefore I will now, let me just ask, is there any other comments? No, so I will now put the question. Honorable Senators, the question is that Clause 3 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 3 as amended now stands part of the bill.
Clause 4.
The question is that Clause 4 stand part of the bill.
Mr. Chair, the government has proposed amendments, as we have also noted Senator Drayton does. If you would permit me to lay ours first?
Sure.
Much obliged. Mr. Chair, coming out of the submissions in the debate from the independent bench and coming out of our discussions with the non-profit organization sector in the days that we have had, both post the House of Representatives and also post our sitting in the Senate, we recognize, and I want to thank Senator Vera for putting it in very clear fashion in the course of his contribution, we recognize that there is a need to be expressed in the law, whilst the government was content with the law as drafted, because the regulator is the FIU. Under the Financial Intelligence Unit law, you can only be regulated as the FIU would regulate you, and then you would go to that act, and that act would say that you have to have guidelines and rules, etc. We felt that there was powerful logic in Senator Vera's recommendation that we expressly provide for this and not rely upon the implication of law. And so we propose, Mr. Chair, that we apply the risk-based identification in Clause 4 by insertion of a subclause 3. And we propose that that read, where a non-profit organization under subsection 1 is registered under this act, the regulator shall, using a risk-based approach, determine the level of supervision required for the non-profit organization under the Financial Intelligence Unit of Trinidad and Tobago Act. Now, I made skipping reference there to the entity under subsection 1. We propose that subsection 1, this was the second recommendation coming out of Senator Vera's contribution, that we ought to consider what thresholds look like. And therefore, we propose in subsection 1A, and this is open to discussion here, we have proposed that entities with a gross annual income exceeding $500,000 be subjected to the FIU's supervision. Any non-profit organization with a gross annual income under $500,000 will not be subjected to regulation. That would therefore allow us, solely on the basis of monetary size, to have 3 categories of treatment, with then subcategories of disaggregation via the FIU. And I'll explain that. 1, non-profit organizations under $500,000 of gross annual income are not subjected to regulation. 2, the second category, non-profit organizations that have a gross annual income between $500,000 and $10 million will have the obligations, of course, of keeping their records, etc., but they will not be required to take the step of having audited financial statements prepared pursuant to Clause 15. Those that have gross annual income above $10 million, we say, have to mandatorily have their audited financial statements produced annually. The subcategorization treatment is that the FIU will, after it has some time to get into this law, because the FIU comes to regulate you via guidelines. And I'll give the example, and this is really speaking through you to the public, Mr. Chair. When the attorneys at law were introduced into the first schedule of POCA, the Proceeds of Crime Act, for supervision by the FIU, first things first, not all attorneys at law were required to comply. There was a disaggregation of the type of work. Advocates who practiced in court and solicitors as instructing attorneys had no business in there. We went instead for attorneys at law who posed a risk to issues of terrorist financing or money laundering, so property and conveyancing and incorporation of companies. But those guidelines took several years to be produced. And it was only after those guidelines were produced, there was public consultation, there was education, then and only then did the regulator take the step to cause compliance via the regulations, cause compliance via the guidelines, and slowly warm up the sector. So I want to give the absolute assurance that with the express amendment that we propose to Clause 4, coming in the language of subclause 3, which we impose, we are asking for different sizes to fit different people on a risk-based approach after the FIU produces its analysis and guidelines on that basis. And those are the in-the-round reasons for our proposed amendments to Clause 4.
Senator Mark?
Vice President, this amendment being proposed by the Attorney General is going to make this bureaucrat within the FIU judge, jury, and executioner. This is not keeping with democratic practice and principles. And as far as we are concerned on this side, the risk-based approach that the regulator is now going to be pursuing to determine the level of supervision ought to have been done before this bill entered the chambers and was tabled in the Parliament. So to give the regulator the power, Mr. Chairman, to determine a risk-based approach in order to determine whether they will supervise X or Y organization does not really make sense. And further, Mr. Chairman, we would have preferred that we remove the post or the office of regulator from the Financial Intelligence Unit, and we have what is called an NPO commission that is independent, that is not ministerial, and that is directly accountable to the Parliament. This FIU is not independent, it is under ministerial supervision, and we believe that these NGOs, which are independent organizations and engage in independent activities, ought not to be under the supervision of any regulator called the FIU. So I want to make it very clear, we do not support this particular amendment that is being proposed by the Attorney General.
Senator Richards?
Thank you, Mr. Chair. 2 points of clarification for the Honourable AG. First, I agree with the benchmarking as suggested by Senator Vera and taken up by the Attorney General of the $500,000. And just for clarity, is this an indication that non-profit organizations under gross annual income exceeding of $500,000 do not have to be registered, or do they still have to be registered?
There would still be a registration requirement. So that is that, let's get everybody on one register approach. And that's really, well, I'm sorry, I suppose you wanted to take the questions in the round, so I'll hold my reply.
And two, appreciated with the response. And two, so I agree with that in terms of those over 500,000 being under the supervision of the FIU. But if you could advise on why the $10 million benchmark, as I indicated in my deliberation, I found it still too lenient in terms of those that needed to provide audited financial reports.
Can we take that, Mr. Chair?
Let me find out from you, your good self, if you're able to, given, let me see how many members want to comment on this particular clause, amendment, sorry, as put forward by the AG. Senator Vera, that's it? AG, would you be able to?
Sure, I'm taking notes.
Okay.
Yes.
Senator Vera.
Thank you, Chair. Just to say, I think that these amendments really achieve the objective that everybody wanted, which was to have a risk-based approach. And I think it's, just to echo what the Attorney General has been saying, it's very difficult to crystallize at this juncture for everybody. There has to be a certain amount of investigation and an analysis, and then policy develops organically. It doesn't make sense unless you do it. The FIU has been around for a while. They have the experience, they have the expertise, and their functions and powers are very clearly set out in the FIU Act.
May I, Mr. Chair?
Yes.
In relation to Senator Mark's most astonishing submission, and I want to explain why I say astonishing. The Financial Intelligence Unit Act, Chapter 7201, is an Act of Parliament, number 11 of 2009. It was amended in 2011, 2011 again, 2012, 2014 by the UNC government. And for Senator Mark to scandalize the FIU by saying it is judge, jury, and executioner and it is not independent, makes a mockery of the fact that the UNC, when it was the government, kept the FIU in its very form and fashion. Now, let me deal with the fake news and scandal of the submission. And I have to be very serious about this because very simple people who do a lot of good work in the NPO sector are listening to this debate and run away with submissions. The scandal in saying that the FIU is judge, jury, and executioner is to be dismantled immediately when you realize the executioner under the law is that it is to be had by the FIB, the Financial Investigation Branch, which is a division of the Trinidad and Tobago Police Service. The FIU's responsibility since 2009, and during the 5 years and 3 months that the UNC was government and left it the way it was, is simply to receive suspicious activity reports and suspicious transaction reports, create typologies and trends, do analysis, guidelines, etc., perform functions which are specified under law, and if there is any investigation of terrorist financing or money laundering, they send that to the police, the Financial Investigation Branch. So for me to sit here and hear Senator Mark make it up as he goes, or rather reinvent the law, which the UNC left in its pristine form for the entire time that they were the government, is a hard pill to swallow, Mr. Vice President. And this is why I started off by saying, if the opposition has amendments, I want to see some written amendments, not just make it up as you go commentary on the law.
Let me
just this nonsense.
Senator Mark.
That the Attorney
Senator
General.
Mark, 1 second. I want to maintain control of the proceedings, and I don't want it to run away. Right? Great. Attorney General, I'm just going to ask, because you responded to Senator Mark. So continue to respond to everyone that has made comments on this particular clause thus far, and then we will treat with any other comments after that.
Thank you, Mr. Chair. I reject Senator Mark's contribution. Makes no sense. It's divorced from the law, and it is a scare tactic,
Mr.
which I do
Chairman.
not accept from my point of view.
Senator Amin,
If I go to
One second, Attorney General. Senator Amin, I have asked the Attorney General to respond to all comments that have been stated just for. I'm trying to maintain a particular procedure and order for a smooth flow of this process. So everyone who wanted to respond to the first comments or the introductory comments of the Attorney General on the proposed
and I do
amendment.
appreciate that, Mr.
Let me
Chairman.
finish.
Mm-hmm.
The Attorney General has made his introductory comments
Yes.
on his proposed amendment for Clause 4. I invited comments from other members and allowed those comments to come forth before the Attorney General responded. I'm now allowing the Attorney General to respond to all of those comments
Mr. Chairman,
that
may
came
I?
before. 1 second. So let the Attorney General respond, subsequent to which I would invite one more round of comments, which you can then say whatever you want to say at that point in time. Attorney General, continue. Thank you. Senator Richards raised the question of benchmark, indicated satisfaction with the benchmark of the lower bracket. I thank Senator Vera for his reinforcing the prudence of taking a start first and then getting the FIU into its typologies and trend analysis. As for the $10 million, that mark is wide open for discussion. It comes up technically in Clause 15, where we really set that, so it's not really anchored in this particular clause. The only anchor that we put here, again for discussion, was the 500,000. And if I could say we chose 500,000, I could say quite arbitrarily in some senses, but then there's an anchor as it relates to value-added tax. So we chose the value-added tax ceiling at $500,000. We felt that was known to most people, that we would apply that particular standard. As it relates to the 10 million, I welcome the discussion of the committee as we get to Clause 15, where we'd have that square in focus with an ability to amend it if necessary.
Thank you. And just if I could respond, Chair, through you.
So you've completed your comments in relation to Senator Vera, Senator Richards, and Senator Mark. Senator Richards, and then I will allow Senator Mark. Senator Richards.
Thank you. Through you, Chair. AG, does that mean that, like in other bits of legislation that we would have debated and come to committee stage, that, and in legal terms, that means that the FIU will have remit to, because as Senator Vera indicated, as the information comes in to the FIU, should this bill become law, they will have information upon which to make judgments and tweak as they go along. Would it be an upper limit and left up to the jurisdiction of the FIU to lower it if they realize there are issues, or would that be a fixed benchmark if it is passed to this stage? Because we can understand that information coming in, as Senator Very indicated, will actually inform the FIU as to how best to operate in this new paradigm.
Sure. Because it's primary law, and because we're fixing the amount in primary legislation, the FIU has no discretion to amend that unless Parliament does so. You'll see by the number of times we've amended the FIU Act and different pieces of law, particularly as it relates to terrorist financing and money laundering issues, that as the trends and typologies feed back into the world environment and the local environment, Parliament is often moved to adjust limits. So in truly getting to the risk-based approach model, the first thing we got to do is to get everybody registered. Once we get them registered, we're putting some rough milestones in place here now. We're saying $500,000, you're out, but you're still registered. That allows the regulator and people who now receive, okay, we've got 20,000 NPOs as opposed to just 8. Let's assume that the number grows by 2 times the amount, 16 to 20,000. It now allows for the exercise of the FIU to have a look at what these people are doing in terms of typologies and trends. It then allows for the governmental arms to consider risk analysis, etc. Now, I want to say something. We have already commenced the exercise of drafting other laws to treat with the NPO sector. I don't want to say a charities commission because the name may not be that, but we're looking at the wider issues of charities. But NPOs are so much more than charities. That's why I'm being careful about the name, right? So we're looking at an NPO companion law which would treat with the larger issues. This law is intended to be fixed under a parliamentary ceiling. It will only be able to be moved if Parliament changes that, but it's definitely going to be something under consideration as the information starts to come back and resonate.
Final point of this, through you, Mr. Chair. Well, then I'm even more adamant about lowering that benchmark, because
when we
just in terms of a concept, imagine 10 or 15 NPOs unaudited at $10 million, what that could mean.
When we get to clause 15, I welcome.
Okay, so Senator Mark, you have comments. Let me just, before you speak, Senator Amin, do you still want to say something?
Mr. Chairman, I appreciate your efforts or your indication to keep order in the committee. But I just want to suggest for everyone, we cannot have order if we are going to refer to people's comments as nonsensical and untruth and ingenuine. And if we are to have order, it has to go on both sides. And I'm seeing a level of disrespect to the chair today, Mr. Chairman, that I find in poor taste. And I just want to say that for the record.
Senator Mark.
Mr. Chairman, I just want to say before I make my contribution, I am not in the business of spreading fake news. The only person who I know has engaged in that is the Attorney General in the Ram Logan case. Okay. So I don't engage in fake news.
Yes.
I don't engage in that.
Members.
I don't engage in that.
Members.
Okay? I don't engage in fake
Members.
news. Okay?
Do not want. Yes, Attorney General, one moment. I really don't want to, at this early stage, to have to suspend just to maintain order. We have 29 clauses and one scheduled to get through. We are on clause 4, and there's a second amendment put forward by Senator Drayton. We could be here till 2, 3 in the morning if we continue like this. Let just members understand that first and foremost. When, and this goes for both sides, moving your amendment and making your comments, let us stick to the bill that is before us. Let us leave out as much as possible the extra seasoning. And I'm sure order will be maintained. So, Senator Mark, if you are responding to the Attorney General's response of your proposed suggestions for this clause, do so succinctly.
Mr. Chair, I must, for the record, because it's been said on open mic, recorded by Hansard and played, refute Senator Mark's statements about fake news. And I characterized, you see, this is why I asked in the beginning. So I must refute it for the reasons stated. And you see that, Mr. Chair, is important because then it is reread,
Mr. Chair.
Mr. Chair,
I'll respond to him.
in a different light.
No, he's disrespecting the chair. The chairman ruled. No, but he has the right to make whatever comments he wants to make.
And again,
But me?
Senator Mark puts on his microphone.
Enough is enough. I do not. Senator Mark. Members, this House will be suspended for 15 minutes.